Good morning, Representative Biederman. Can you hear me?
Yes, I can. I hope you can hear me.
Yes, sir. I sure can. Thank you.
Well, I'm sorry that I couldn't get in on the audio, on the video part of this, so I had to call in. So,
oh, that's fine.
I'll be here to listen. Okay.
All right.
Thank you.
Thank you.
Well, good morning. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, November 4th, 2020. Time is 9:30 a.m., and I'll begin with the roll call. Good morning, Commissioner Lindley.
Good morning.
And good morning, Commissioner Janeka.
Morning, Chairman.
Our commissioners are all present. How about our General Counsel, Ms. Smith? Are you there?
I am. Good morning.
Good morning. And our Public Interest Counsel?
Good morning. I'm here.
Good morning, Mr. McWhirter. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online, and that link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration closed at 9:30, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and identify the item that you'd like to comment on, and we will do our best to accommodate the request. For those who are making presentations, please wait to begin until either I or our General Counsel have asked you to begin speaking. And when you do, please check to make sure that your line is unmuted before you speak. We have members of the legislature who are signed in to speak on items 2, 3, and 4 this morning. We appreciate their participation in our agenda meeting, and out of deference to their time, we're going to take things out of order to hear from them first. So we'll take up item 2 first, then we'll take up items 3 and 4 together, and following that, we'll return to item 1. So with that, I'd like to thank everyone for being present, and Ms. Smith, please call the caption to item 2.
Item number 2 is the application by Silesia Properties LP for new TCEQ water quality permit number WQ001-583-5001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record. As the commission customarily allows members of the Texas legislature to address it on hearing request matters as a courtesy to the elected officials. However, the commission will make its decision based on the timely filings in this matter. Representative Biederman and Mr. Larry Bailey, a member of his staff, are present at today's agenda and would like to address the commission.
Good morning, Representative Biederman and Mr. Bailey. I'll turn it over to you. The floor is yours.
Well, thank you very much. This is Representative Biederman. I'm sorry I can't be on video, but I really appreciate the opportunity to address the commission, and appreciate all that you do. And I'm actually very honored to be working on legislation and working very hard to try to increase the powers that we have in these permits, and to really focus on protecting not only the hill country where I live, but the state of Texas' environmental sensitivities. So thank you very much. And I believe Larry Bailey, my Chief Policy Advisor, will be reading a letter into the record. Is that correct, Larry?
Yes, sir. We would like to.
That's great. Thank you, Representative Biederman. And Mr. Bailey, go ahead whenever you're ready.
Thank you very much, Chairman Neerman and Commissioners Lindley and Janeka. Thank you so much. This letter is dated October 22nd, 2020. It is addressed to Chairman Neerman. Thank you for giving me the opportunity to address you and the other TCEQ commissioners regarding the Silesia Properties applicant's proposed wastewater permit. Due to the unique circumstances that I will identify later, I strongly support the TCEQ issuing a final wastewater permit for Silesia Properties or Honey Creek Ranch mud. Protecting the Texas Hill Country sensitivity areas should be the guiding priority for all wastewater discharges permits, and that was the goal and priority for this permit. I do believe that the extra levels of state regulatory protections, like those proposed and agreed to by Silesia Properties, need to be institutionalized to ensure the unique environmental areas in District 73 and across the state. Due to the substantive community outreach efforts made by Mr. Urbanzik, the applicant, including his change to a new draft permit and other commitments, I see this as a model enterprise and a standard for other property owners and developers in the Texas Hill Country and across the state. You can imagine my surprise when I learned last week that the Office of Public Interest Counsel and the TCEQ Executive Director submitted filings recommended a contested case hearing to the TCEQ commissioners. I immediately set up a virtual meeting with Mr. Anthony Tatu and Ms. Farrell Fields. After they briefed me on the TCEQ process, the two separate filings, and the meaning of the terms relevant and material, Larry Bailey and I provided them our observation on the applicant's communications with the stakeholders. Mr. Tatu informed me that the community outreach efforts made by the applicant to resolve the more significant stakeholder concerns were not considered as part of OPIC's or the TCEQ Executive Director's consideration to recommend a contested case hearing. Also, he said that the relevant and material issues identified in the TCEQ Executive Director's filings were combined from the input submitted by the determined affected parties. This is disturbing to me because the Executive Director's response to comments submitted by these stakeholders indicated that the TCEQ had no jurisdiction over these issues. If the agency has no jurisdiction, how can these issues be deemed to be relevant and material? Moreover, the applicant addressed all of these issues either in the permit or his outside the permit commitments. The one area the applicant did not address is because the stakeholders did not respond to his idea for establishing an environmental fund for Honey Creek Springs. Since being elected in 2016, I have observed how special water districts have been created in the Hill Country to develop property and construct homes. I have had lengthy and in-depth conversations with different property owners and developers regarding their sincere desire to protect the Hill Country's natural resources. Unfortunately, too many developers have not followed up on their natural resource protection commitment. Additionally, while existing state environmental regulations are in place to protect the Hill Country watersheds, I believe the Hill Country has watersheds with certain sensitivity areas that require more stringent standards. All types of available water are essential to the future growth of the Hill Country, and domestic wastewater treated to very high standards needs to be an important element. This is the background information that leads me to my position on Silesia Properties draft permit. I observed over the past 2+ years that the owner of the property, Mr. Ronnie Urbanzik, has used an assertive approach in establishing a positive rapport with the public who is directly impacted by his planned development. His objective was to be successful in pulling together diverse interest groups to provide each with a better understanding of how all the stakeholder issues impacted the larger development. He has been reaching out extensively to the public, elected officials, state agencies and their staff, advocacy groups, and adjacent landowners to find out their concerns about his plans for this project. The stakeholders knew his concerns were genuine and that he was passionate about being transparent about the total project. He listened to their claims, including wanting the wastewater permit to be denied, wanting the project to be stopped, wanting the housing density to be reduced, wanting Honey Creek Springs and the associated cave system to be protected, wanting the groundwater to be protected, and wanting stormwater measures installed to mitigate the runoff. He listened to these stakeholders, most of whom were people living closest to the property and those who had specific interest in protecting Honey Creek. I've gone into more details on this in the attachment. Based on the applicant's formidable community outreach program, I can't see how a contested case hearing will be beneficial. I realize that the commissioners rarely override the director's recommendation, but I believe that this wastewater permit should be the exception. The identified positive efforts of the applicant clearly show why this wastewater permit should be granted with no contested case hearing. I will be attending the scheduled virtual hearing on November 4th when this draft permit is to be heard. I will be available to answer any questions you have. I also recommend that you ask questions of the applicant at the time regarding the basis why he made all of the substantial and impressive permit changes and other commitments. There is an attachment. Am I allowed to read the attachment? Is that
Yes, sir.
Thank you very much. Attachment 1, Celestia Properties, LP Community Outreach Program. Extensive discussions took place with the TCEQ, the Texas Parks and Wildlife Department, and different stakeholders that resulted in him, the applicant, changing his already submitted discharge permit to a land application permit. In reaching his decision, I understand he considered other options like piping the wastewater out of the Honey Creek watershed to a property that drains into an adjacent watershed. This viable engineering option fell through because the adjacent landowner/developer required some unreasonable demands. Mr. Urbanzik also evaluated placing homes on 1/2 acre lots with septic tanks. However, the public responded that option would likely contribute many pollutants to the Honey Creek watershed. He listened to their concerns and decided not to pursue that option. I believe that all the feasible options were considered before the land application option was ultimately selected as the preferred remedy. Because of his new TLAP approach and raising the effluent quality to one of the highest in the state, Mr. Carter Smith of the Texas Parks and Wildlife Department agreed that the new permit met the agency's requirements for protecting the quality of water and wildlife in Honey Creek. A new permit was now required and the permitting process started from the beginning. An informed decision was made based upon input from the public and other key stakeholders that a land application permit would be found acceptable. The stakeholders made it clear that this was their primary goal and that applying the highly treated effluent to the land is much better than discharging the effluent into Honey Creek watershed or allowing septic tanks to be installed. Mr. Urbanzik took further steps to meet additional stakeholder claims. Mr. Urbanzik agreed to a much higher level of plant treatment. His decision also included significant removal above that required by the TCEQ. These high-level treatment selections informed the stakeholder that he was serious about protecting the Honey Creek watershed. In one exchange meeting with the public, he offered to contribute to an environmental fund for Honey Creek Springs. Unfortunately, he never received a response. Additionally, Mr. Urbanzik informed the stakeholders that he had agreed to implement the following measures. There are 4 of them. Groundwater wells would be installed and the data collected would be shared with the public. The developer of the property would be required to install a lighting system that was consistent with traditional dark sky ordinances. The developer of the property would be required to inform all homeowners that they would be restricted from using certain insecticides, herbicides, etc. And the proposed housing number would be reduced from around 27 homes to approximately 1,800. That concludes the letter from Representative Biederman.
Thank you, Mr. Bailey. I appreciate that. And Representative Biederman, thank you very much. I appreciate you participating and addressing the commission this morning.
You're very welcome. Thank you.
Well, colleagues, I do appreciate Representative Biederman's comments, and among them the outreach to the neighbors, the community outreach. I think is really important and valuable for any regulated entities. The regulated entities that do engage with their neighbors in a constructive way do tend to have greater success. But of course, what's in front of us are requests for a contested case hearing. And as you know, Texas law requires a 2-part analysis for our considering requests for contested cases. And for the benefit of those who are not familiar with the process, we first consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case. And then, assuming that at least one requester meets the requirements, we will then consider which issues are appropriate to refer for hearing. So part 1 is about who gets a hearing, and part 2 is about which issues are referred. Requesters who are affected in a manner different from the general public and who have articulated personal concerns that are relevant and material to the permit and have done so both in timely comments and a timely hearing request are entitled to a hearing. There are special rules for associations. Associations can have standing if they name at least one member who would have standing in his or her own right and raise issues that are both germane to the organization's purpose and relevant to this application. So in this case, we have a dozen hearing requesters, and I believe 5 of them are affected parties and therefore entitled to a hearing. As for the associations, the Bulverde Neighborhoods for Clean Water, the Greater Edwards Aquifer Alliance, and the Texas Cave Management Association all raise relevant and material issues that are germane to the organization's purpose and identify a member who would have standing in their own right. So I would grant their requests. Save Our Springs has failed to adequately identify a member who would have standing in their own right, so I would deny its request. As for the individual requesters, I would grant the requests of Dennis and Joanne Dawson, Joyce Moore, and Honey Creek Springs Ranch Limited Partnership. The Dawsons reside on property adjacent to the proposed facility and have raised relevant and material issues in timely comments and hearing requests. Ms. Moore, on behalf of herself and her limited partnership, also timely raised relevant and material issues. Her property is roughly a mile from the applicant's property, maybe slightly more, but importantly, the 2 properties are connected by a stream, which in my view distinguishes her interests from the general public. And then I would deny the remaining individual requesters. Mr. Elmdorf's comments failed to timely raise personal justiciable issues that are relevant and material to this application, and the remaining requesters simply reside too far from the proposed facility to have an interest different from the general public, or they otherwise fail to identify a personal justiciable issue. So let me pause there, and colleagues, see how you came out on identifying requesters who are entitled to a contested case. And Commissioner Lindley, let's begin with you.
I'm in agreement on the named parties. So.
Thank you. Commissioner Janeka?
Likewise. Thank you, Chairman, for laying out the necessary factors that we're required to consider in making this decision. And like each of the other 2 of y'all, I came to the same conclusion, analyzing the record before us and the factors that we're required to review. I found the same parties to be affected.
Thank you for that. All right, let's turn to the issues. And again, for the benefit of those who aren't familiar with our process, we refer issues of fact that have been timely raised by an affected person and that are relevant and material to the application. So to put it another way, the issues have to be within our jurisdiction on this particular type of application. So for example, we're not allowed to consider economic impacts, such as effects on property value. We can't consider the density of development that's beyond our jurisdiction. We can't consider light pollution and so on. So with that in mind, colleagues, I've identified 8 referable issues, and they are as follows. The first is whether the draft permit will be protective of nearby groundwater and surface water quality, whether the draft permit will be protective of the health of the requesters and their families, and of livestock and wildlife, whether the operator requirements are adequate, whether the effluent volume estimate is adequate, whether the facility design satisfies the drip disposal rules, whether operations under the draft permit will negatively impact the affected person's use of their property, whether the application rates under the draft permit are adequately protective, and finally, whether the applicant properly demonstrated a need for the permit as required under Texas Water Code Section 26.0282. So those are the issues as I see it and how I would organize them. Commissioner Lindley, how did you come out on the issues?
I came out the same way on those 8.
Commissioner Janeka?
I reached the same conclusion. Thank you.
Okay, and I think it would be appropriate, certainly given the number of parties and issues, to allow the full 180 days for SOA to complete their work on this matter. And if you all agree, I'll entertain a motion.
I would agree, and I can say motion, and I guess I'll just make one more comment. I didn't really comment on the representative's letter, but I would say from what I could see in the record, I did find it, just for me, impressive how the applicant, it appeared, tried to work with the community and listen to their requests and their comments, and I know at one point withdrew and refiled, and I appreciate it when companies do that, and I've definitely picked up on that in the application, and I hope there are other applicants out there that if they're about to go through this process would take note of. If you get out there and you do a bit of outreach, that's always a good thing. What's before us today, though, is looking at the individuals and the other entities that submitted a hearing request, and what we have to decide is, did they meet the requirements to meet a hearing? And so that's really what is before us today. And just looking at those facts, I do feel comfortable that we should grant the hearing request, as I already stated. So, sorry, should have probably made that comment a few minutes ago, but I felt like I should make it now. But I will move that we grant the hearing request filed by Bulverde Neighborhoods for Clean Water, Greater Edwards Aquifer Alliance, Texas Cave Management Association Incorporated, Dennis and Joanne Dawson, and Joyce Moore, and the Honey Creek Spring Ranch LP Limited Partnership. I would move that we deny all remaining hearing requests and all requests for reconsideration, and that we refer the application to SOA for a contested case hearing concerning the following issues. A, whether the draft permit will be protective of nearby groundwater and surface water quality. B, whether the draft permit will be protective of the health of requesters and their families, livestock, and wildlife. C, whether the operator requirements of the draft permit are sufficient to ensure adequate management and oversight of the facility. D, whether the applicant provided an adequate effluent volume estimate in the application. E, whether the design of the facility will satisfy the requirements of the subsurface area drip disposal rules. F, whether operations under the draft permit will negatively impact affected persons' use of their property under applicable regulations. G, whether the effluent land application rates under the draft permit are adequately protective. And H, whether the applicant properly demonstrated a need for the permit as required by Texas Water Code 26.0282. And finally, set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. We were at this point going to move on to items 3 and 4 and take those up together. And we were going to hear first from Representative Cyrier. But I'm not certain if he's on the line. So if he's on the line, we'll go ahead with 3 and 4, and if not, we'll move back to number 1. So let me ask Representative Cyrier, are you or someone from your office on the line here with us? All right, hearing none, why don't we move back and we'll take up item 1, and then we'll get back to items 3 and 4. Ms. Smith, if you'll call the caption to item 1, please.
Item 1 is the consideration of the administrative law judge's proposal for decision and proposed order assessing administrative penalties against Bachana S. Mao doing business as NV Food Mart. The order of presentation will be the executive director, followed by the respondent, and then OPIC. Each party will be allotted 5 minutes of oral argument time in accordance with the Commission's standard practice. The executive director may save time for rebuttal as the ED bears the burden of proof.
Good morning.
Good morning.
Good morning. Good morning. Can you hear me?
I can.
Yes.
Thank you.
Great.
Do you go?
Ms. Mao, I understand that you're signed in to speak, and we will give you your 5 minutes as soon as our executive director staff is finished. If you'll just hold tight for us, and we'll get to you in a moment. And I'll ask the executive director staff to go ahead, please.
Thank you.
Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I am Clayton Smith with the Litigation Division here on behalf of the Executive Director. With me on the line this morning is Elizabeth Sloan with the Austin Regional Office and Ken Moeller with the Enforcement Division. This enforcement case involves an underground storage tank system owned and operated by a respondent. The ED alleges respondent failed to timely report and investigate a suspected release after inventory control records indicated potential releases from 2 tank compartments. In the proposal for decision and proposed order, the administrative law judge found respondent failed to report and investigate a suspected release from only one of the tank compartments. The ED filed exceptions, arguing the record supports a finding that both tank compartments had suspected releases that were required to be reported and investigated. No other parties filed exceptions or replies to the ED's exceptions. The ALJ's exceptions letter agreed with the ED and recommended adoption of all the ED's recommended changes to the proposed order, with the exception of a finding of fact regarding the filing date of respondent's answer. The ALJ is recommending respondent be assessed a penalty of $12,532. The ED agrees with the ALJ and respectfully requests you adopt the ALJ's proposed order as amended by the ALJ's exception letter. And with that, I'd like to reserve the remainder of my time. Thank you.
Thank you, Mr. Smith. Colleagues, any questions or comments for Mr. Smith at this time? Okay. Ms. Mao, this is your turn to talk, and thank you for being here this morning. And you have 5 minutes, and you can just state your name for the record, please, and then go ahead and make your presentation.
My name is Fachana Mao. I'm the owner of NV Food Store, and I accept the offer, the 11,407 proposal from TECQ, which is, to me, it is fair because there is no leak, and the test result show it just my niece, she works at that gas station. She just make a little mistake that she forget to take the milk grade, pot of milk grade at 65% to the regular and 35% to super. So that's why it showed that water leak, and then there is no leak, and we have a window route that tests the water that every day that is no leak. You know, at one time it leaked because it rained really big. It leaked from the probe, because we have the test, a tie-in test that come in and test the gas tank. Then I asked them why the water is leak. They said because the probe, they come from the probe. And so that's all. I just asked all the TECQ to give me this proposal. You know, that I asked you that you offer, the judge offer for 11,407, because it is, to me, is fair, because if there is no leak at all, if leak, I will take full responsibility for that. And everything it show on time test, and then the window route, except sometimes the window route, when it rains really hard, it stop working, and then it's not easy to call those company to come in and fix because they too busy. So we change the window route, and then everything is accurate every day. You come in, they test every morning, and then they test a monthly test. So the monthly test we have to keep for TECQ when we come to inspect. And sometimes, it's accidentally, it's that month, you run out of paper, they then print out, and I don't know how to reprint it. You miss those 1 month, then they give us a hard time too, you see. So So it's like that. So if they have the water in there, they show on the window would have water, how many in, this and that. So we have to call the company and take it out. But we never have any problem of the water. You know, it's those years is a lot of rain. So like that. That's all I can ask. That's all I can. I don't have any more to say, sir. That's all I just asked to.
Okay.
Yeah.
Thank you, Ms. Mao, for your comments and your presentation. And I am familiar with the facts of this case, and do appreciate your presentation. I don't have any questions or comments for you just at the moment, but let me ask my colleagues. Commissioner Lindley, any questions or comments at this point?
No, thank you very much.
Commissioner Janeka?
No, I appreciate your comments today. Thank you.
And Mr. McWhirter, we'll hear from OPIC next.
Yes, sir. Pranjal Mehta is the OPIC attorney who represented our office in this hearing. I believe she's on the line and will give our presentation.
Great. Go ahead when you're ready.
Good morning. I'm Pranjal Mehta. I represented OPIC at the hearing on this matter. OPIC recommends approval of the proposal for decision as modified by sustaining the executive director's exception. Thank you, and I'm available for any questions.
Thank you, Ms. Mehta. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thanks.
And we'll return to the executive director. You have some time reserved for rebuttal if you'd like to use it, Mr. Smith.
Thank you, Chairman. Nothing further from the ED unless you have any questions for us. Thank you.
None here, and I think I'm seeing an indication from my colleagues that they don't have any questions at this point. They're invited to jump in at any point. But colleagues, let me begin by saying that I am very sensitive to the burden that a $12,000 or $13,000 penalty places on a small business. However, the relevant statutes and rules and guidance require that. It's consistent with our prior practice with respect to these types of underground storage tank violations. And since these violations can and often do present a risk of serious harm to our environment, they are supported by a clear policy rationale. But even more to the point, what we have before us is a proposal for decision from SOA, and we would need some basis in order to overturn that. And I can find no basis in the record to set aside a finding of fact or a conclusion of law, and therefore I don't see how we're able to depart from what has been presented to us. And for those reasons, I think we're compelled to adopt the proposed order with the modifications that have been agreed to by the executive director and the administrative law judge. And those are the ones, as you know, that relate to tank 2B. So that's my view of this matter. Commissioner Lindley, how do you see it?
I came down the same way, and I appreciate all the comments you said. It is difficult to swallow. Kind of sometimes the penalties that are brought upon smaller business owners, but I didn't find anything in the record, and I like the way you said it, that I agree, and I found no basis to overturn the ALJ's PFD. So I would be comfortable adopting what's before us today.
Thank you. Commissioner Janeka?
I appreciate those comments from each of you, and I'm in agreement. I'm very sensitive to Ms. Niles' comments about experiencing some frustration or confusion or arguing the penalty today because there was no leak. And I appreciate that the rules really go towards and the requirements go towards ensuring there isn't a leak. But part of our responsibilities in ensuring for the public that all operators in the state are following fully our rules. The requirement here was to investigate and prove to us that there was no leak, and that wasn't done as our rules required. So for consistency's sake, I'm comfortable moving forward, and I will move for us today that we adopt the ALJ's proposed order with the modifications recommended by the ED's exceptions and agreed to by the ALJ's reply.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. We'll now move on to items 3 and 4. Ms. Smith, if you'll call that caption.
Items 3 and 4 are the consideration of the petitions for revocation filed by Central Texas Airport, LLC, concerning municipal solid waste notification numbers 47068 and 47070, issued to employee-owned nursery enterprises limited, doing business as Organics by Gosh.
Thank you. Before we go ahead, Ms. Smith.
I do not believe we have anyone from Representative Syrier's office on the line.
Let's check that. Representative Syrier, are you there? All right, hearing none, I'll let you go ahead, Ms. Smith.
The petitioner, Central Texas Airport, LLC, is the moving party and should present the matter first, followed by employee-owned nursery enterprises limited, then the executive director, and then OPIC. By letters dated September 4th, 2020 and October 5th, 2020, the parties were notified that they will be given 5 minutes for oral argument on each petition, and the petitioner may save part of its time for rebuttal. There are some interested non-parties signed in and on this item, and their presence will be noted for the record.
Thank you, Ms. Smith. And I understand that Mr. Tuckfield is here for the petitioner. And good morning, Mr. Tuckfield. I'll ask you to state your name and affiliation for the record, and then the floor is yours.
Good morning. My name is David Tuckfield. Thank you for having me here. I represent Central Texas Airport, LLC. And I appreciate the opportunity to be able to make this presentation. We have CTA, Central Texas Airport, has filed 2 petitions for revocation. Both petitions rely on the same basic premises. First, there's no dispute that the applicant failed to provide CTA with notice. In both cases, CTA was entitled to notice as an adjacent property owner, and they were entitled to notice as an affected landowner, both of those things. And I think, and by affected landowner, I mean there is harm or potential harm that's different from the members of the public. And so both of these issues are important in these petitions for revocation. We briefed these issues extensively, and I'll reserve the remainder of my time for rebuttal.
Thank you, Mr. Tuckfield. Colleagues, any questions for Mr. Tuckfield at this point?
No, thank you.
Okay, hearing none. Mr. Reed, I understand you're here for employee-owned nursery enterprises?
Yes, Commissioner, thank you.
Good morning. Go ahead, please state your name and affiliation for the record, and then the floor is yours.
Good morning. My name is Jeffrey Reed, for the record. I'm representing employee-owned nurseries enterprises doing business as Organics by Gosh. And I want to thank you for taking the time to look into this matter. I'm confident that after you do, you'll dismiss Central Texas Airport's petition. The executive director agrees that this matter should be dismissed. This is because CTA is trying to change the notice rules and practices that have been in place for decades. People make business decisions in reliance on those rules. E1 and the ED acted in good faith on those rules, and like everyone before them, made significant decisions and investments to grow state-of-the-art business based on those rules. There's only one question raised by CTA that matters. Was CTA entitled to receive notice when E1 filed its NOI to operate the 2 composting facilities? They weren't, not for either NOI. As a legal matter, they weren't. The ED agrees. Any claims that CTA makes about environmental violations should be dealt with in an enforcement context. TCEQ has been to the site, and E1 will always welcome TCEQ to the site whether for information or for a compliance investigation. E1 is the sole organics recycling company for the City of Austin and takes the city's curbside separated green and food waste, as well as green waste from surrounding areas, to make a beneficial soil used in local agriculture and industry. E1 has invested millions of dollars into the 2 sites at issues here, the vast majority on the site that's the subject of the CTA's second petition. It employs, with its local affiliates, over 50 people, and has been operating at these sites for over a year with a completely clean compliance history. CTA has been looking to develop an airport in the area for some time, but with no sign of forward progress in nearly a decade. But the FAA says that because of bird dangers, composting at airports are not good neighbors. And more importantly, CTA wants E1's property, so is looking for any basis to interfere with E1's business. In both of its petitions, CTA first argues that the rule requires notice to affected landowners and not just adjacent landowners. Notwithstanding some awkward wording, the rule is clear. The TCEQ intended notice to be to adjacent landowners, but gives the ED discretion to require notice to other landowners that it finds to be affected. That's what the rule says. That's what the preamble of the rule says. That's what the NOI application form says. And that's been the TCEQ's long historical practice. In all of its filings, CTA ignores the part of the rule that gives the ED that discretion. CTA is not adjacent to either facility, and the ED did not ask that CTA be notified as otherwise affected. Therefore, CTA was not entitled to notice. Realizing that its argument is weak, CTA then argues that adjacent means close to, even if not touching. This goes against common usage and common sense. More importantly, it would put a requirement on E1 that's never been required of any other applicant for notification before, and CTA hasn't cited any. And without any specific distance requirement, how far does adjacent go if it doesn't mean touching? I suppose that it would go out as far as the ED's discretion says it goes. The ED, in its discretion, still didn't find them affected, so CTA's argument here doesn't matter, and they're still not entitled to notice. In both petitions, CTA argues that its property across 969 was entitled to notice even though it's across a highway from both of E1's properties. There's no requirement to notify properties across a highway. The ED agrees. The ED identified other applications where this was the case in its brief. In reply, CTA cites to a court case that has nothing to do with notice, nothing to do with the TCEQ, that's about a city's authority to annex, and where the court in that case said that it could not determine who owns the roads. Not that properties are adjacent if they're across roads. CTA also argues that because E1 identified the Gosh Realty tract in its first application, which is across 969, that proves that E1 should have identified CTA's tract, also across a highway. But just because E1 over-notified in its first application does not mean that it had to repeat that error in its second application. There's no requirement to notify a property across a highway, and revoking E1's authorization when it's not been required of other applicants would be patently unfair to E1, not to mention changing the way the ED has interpreted this rule for decades. In addition to the arguments that cover both of the E1 sites, CTA provided some additional arguments that are limited to E1's first application. First, CTA argues that the entrance road is part of the facility. There are many cases where entrance roads are not part of a facility. You're defending this very issue in an appeal of the 130 EP landfill permit. On September 6, 2017, in approving the 130 EP permit, the commissioners at that time discussed this issue and ruled that an entrance road does not have to be included in a facility boundary. That entrance road creates a gap that's over 70 feet wide between CTA's property and E1's first site. The road and gap were not there to avoid notice to CTA. It's there because that's the road that E1's landlord uses to access its gravel mining operation behind E1's operation. Furthermore, E1 has its own entrance road on OBG3 that it predominantly uses. CTA then argues, related to that first property, that adjacent applies to the entire parent tract on which the facility is located and not just the facility boundary. CTA argues that a fictional applicant buys a tract of land, leases out all but the outer edges to an affiliate, and avoids notice to anyone. But that's not what happened here. And if it were, the rule provides a fix for that. If an applicant were to try to game the system, the rule allows the ED to require notice to properties that are farther away. In our case, E1 leases the tract from an unaffiliated gravel mining company. The edge of E1's lease is more than 1.5 miles from the farthest corner of the parent tract. That parent tract can't be the basis for notice of E1's operations. CTA looks to the application instructions and highlights the words borders the property. They completely ignore the rest of the sentence, where the facility will operate. The property where the facility will operate is the facility in the lease boundary, not the boundary of the parent tract. Revoking E1's authorization because of concerns that someone later might game the system when E1 didn't game the system is ridiculous. If this is truly a problem, it should be dealt with in a rulemaking. Finally, if CTA wants to change the TCEQ's notice rules, they need to file a rulemaking petition and not try to get the commission to do it ad hoc. If they want to prove up violations in the way that E1's facility operates, they need to file a complaint or ask the TCEQ to investigate. Instead, they're trying to use this revocation petition process to try to bankrupt a legitimate business, a significant employer with a clean compliance history, by abusing the TCEQ process. Again, there's only one question raised by CTA that matters. Was CTA entitled to notice? There are no disputed facts relevant to that question. As a matter of law, they weren't entitled, and the ED agrees with that. I therefore respectfully request that the commission dismiss both of CTA's petitions outright. Thank you for taking the time to look at this issue, and I'm happy to answer questions you might have.
Thank you, Mr. Reed. I appreciate that. Colleagues, any questions for Mr. Reed?
No, thank you.
All right. Moving on, we'll hear next from the Executive Director.
Good morning, Chairman Neerman, Commissioner Lindley, Commissioner Janeca, General Counsel with the Office of Public Interest Counsel. My name is Ian Grutch of the Environmental Law Division. With me today is Charlie Fritz and Chance Gooden, both of the Waste Permits Division. Central Texas Airport LLC, or CTA, filed petitions for revocation for two different composting facilities operated by Employee-Owned Nursery Enterprises Limited, or EONE, in Bastrop County. CTA alleges that EONE failed to properly follow TCEQ's notification rules for its two notification tier compost facilities. The Executive Director carefully considered the issues raised in the petitions for revocation, but does not agree that EONE failed to properly follow TCEQ's notification rules. First of all, the Executive Director disagrees with CTA's interpretation of 30 Act 332.22b and maintains that it has long interpreted this rule to require notification only to adjacent landowners. Affected landowners, in contrast, may be notified at the ED's discretion, but there is no requirement to notify affected landowners under this rule. Second, the Executive Director determined that CTA does not own any land adjacent to either of EONE's facilities, and thus, the ED determined that CTA was not entitled to notification in either case. Finally, we want to point out that the requirements for opening a notification tier composting facility were intended to be minimal with the goal of encouraging more recycling in the state of Texas. For example, unlike registration and permit tier composting facilities, notification tier facilities do not have to undergo extensive application reviews and can simply begin operations after submitting an application and securing appropriate financial assurance. In fact, without a petition such as this, the Executive Director has no authority to change or even challenge applications for notification tier facilities. Nevertheless, after evaluating the notices of intent and applications for these two facilities, the Executive Director still found no issues and thus respectfully recommends that the Commissioners deny the petition. Thank you, and we're available for questions.
Thank you, Mr. Groch. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeca?
None, thanks.
We'll hear next from the Office of Public Interest Counsel.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Dominique McLagan-Brown with the Office of Public Interest Counsel. The Commission's Chapter 305 rules provide that revocation proceedings may be initiated by a person affected by the issuance of authorization. The rules further provide that after notice and hearing, the Commission may revoke the authorization for good cause. When a petitioner has been determined to be an affected person, past Commission practice has been to refer the petition to SOA for a contested case hearing. However, OPIC cannot find that the hearing required under Rule 305.68 must be a contested case hearing. It is within the Commission's authority and discretion to consider the notice of this agenda meeting and the proceedings today to satisfy the requirement for notice and hearing. OPIC finds that CTA is an affected person in both notifications, 47680 and 47070, based on CTA's ownership of tracts of land adjacent to the properties where the facilities are located. Regarding adjacency, OPIC agrees with CTA that property boundaries, not facility boundaries, determine which landowners are adjacent. Because CTA owns adjacent property and did not receive required mailed notice, OPIC finds petitioner is an affected person with a right to initiate these proceedings through its petitions. Specifically, for notification 47068, the boundaries of the parent tract owned by Travis Materials determines who is adjacent. The boundaries of the facility operations or the haul road subsumed within the parent tract are not determinative of adjacency. The public must be able to rely on public records, such as the records of the Bastrop County Appraisal District, to determine relevant property boundaries. The Bastrop records identify Tract 12471 as a property where operations occur under notification 47068. And the boundaries of this tract, not the facility, are what should be used to determine which landowners are adjacent. Otherwise, if actual property record boundaries are not used to guide determinations of adjacency, the requirement to provide mailed notice can be subject to manipulation by applicants. For notification 47070, the boundaries of the parent tract owned by Austin Ecolands are determinative of who is adjacent. OPIC also agrees with CTA that the existence of Highway 969 bordering both CTA and the Austin Ecolands property does not prohibit adjacency. In other agency-issued authorizations, TCEQ guidance defines adjoining properties as all sharing a property line or separated only by a road, railway, or river. OPIC recommends that in order to maintain consistency, the same definition of adjacent landowner should be used across TCEQ permitting program areas. For notification 47070, OPIC also notes that the applicant included a property on their adjacent landowner map that is also across Highway 969 and shares a less extensive border with applicant's property than the relevant CTA property. If applicant identified another property across the highway as being adjacent, OPIC questions why CTA's property was not listed as well. For these reasons, OPIC recommends the Commission find that petitioner is an affected person and revoke both notifications based on the applicant's failure to identify all adjacent landowners entitled to mail notice, or otherwise refer the matter to SOA. Thank you, and we are available for questions.
Thank you, Ms. McLagan-Brown. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None for me. Thanks for the input.
Mr. Tuckfield, I believe you have about 9 minutes of rebuttal time if you'd like to take any of that.
I would like to take that, thank you. And Megan, can you put up our slide for item number 3? And let me, while she's doing that, let me just say, the ED said that these requirements were intended to be minimal to encourage composting. Well, they are minimal requirements, but the one requirement that there was one requirement that they needed to do, and they didn't do it. And that's important because this is not just your average small composting facility. This composting facility is taking all of the waste from the city of Austin and putting it in Bastrop County. Now, the E1's attorney, Mr. Reed, said that the rule is clear. The rules intend to give notice to adjacent property owners. So the question here, and we could spend a lot of time on affected, but let's focus on the question of affected, adjacent, given the fact that I don't have a lot of time. When he said that, he said, Mr. Reed said, CTA is not adjacent to the facility. Well, that's not what the rules, it's not what the forms say. It talks about being adjacent to the property. So let's talk about what the E1 would have you accept. The respondents would argue that the applicant can define its own facility boundaries, separate and apart from property boundaries, and then give notice based on that. You'll see on this slide, you're looking at this slide, the applicant's property is outlined in teal, and they've defined their facility as being something less than that property that they lease from the underlying property owner. Well, they gave notice in this case to someone directly across from 969, and by defining their own facility, they gave notice to the south side to Travis Materials Group, who's the underlying property owner. And I suppose on the east side, that constituted the property owner. If you accept their argument here, the result is I could take a 100-acre tract, draw my facility on the interior 10 acres. I could either lease it to myself or to someone else, but I can just draw the facility line myself and say, nobody is adjacent to me except myself or my landlord. And that's ridiculous. I've done a number of wastewater permits. We just did the Salacia permit. The Dawsons were adjacent to the property, not necessarily adjacent to the facility, yet you gave them status as a affected person. It also ignores the reality of the role of property owners. TCQ requires a property owner to join the application, and we note that at Exhibit 4 of the first petition. The property owner is a partial sponsor of the application. It would be ridiculous to say, okay, the property owner is sponsoring the application as well, and so you have to give notice to the property owner. I mean, that's just ridiculous. It ignores the rule that speaks in terms of landowners. It doesn't. The rule at 332.22 speaks in terms of landowners, not tenants or something less than fee simple. And it ignores the instructions. The notice of intent to operate a compost facility states the list should contain the addresses and names of all the landowners whose property borders the property, not the facility, where the facility will operate. So the respondents' arguments about a public road are disingenuous as well. Their first application, our first petition for revocation, they actually provided an affidavit saying that they understand that across the road, and you see on this slide, they provided notice to somebody across the road, that same road. And then in the second response, they say it's not required. So when it suits them, it is required. When it doesn't suit them, it's not required. And as far as the case law goes, the case law is that we cited is very clear. And it wasn't just that case, but that case in footnote 10 of that case cited many other Supreme Court cases that talks about how the fee simple goes to the center of the road. And I know this from experience because I recently had a client who owned some property. His property ended at the road. There was a tank in the middle of, in the road, but on his side of the middle of the road. TCQ told my client, that's your tank. You got to take care of it. And they cited this case. So TCQ is using that in other areas. Respondents also think that a diagonal property is not adjacent, yet they themselves in their response say that adjacent means to be touching. Well, a diagonal property touches at the corners and at the corner, and so that's touching as well. And finally, respondents argue that the term affected has no meaning, and they just write out the third sentence of Rule 332.22. So looking at this slide, you'll see that this property, notice was given to 3 landowners. There's 4 sides of the property, but notice was given to 3. And one of those landowners whose notice was given to is the land upon which the facility sits. Now, how does that make any sense, that you're given notice to the land, the owner of the land upon who you sit? You'll see that in this case, in this first petition for revocation, there's a CTA property that's diagonal. It's on the north side, the northwest side. It's diagonal across the road, and therefore it touches, and therefore they deserve property. And then lastly, the property on the east side of the facility boundary is a CTA property. Megan, go ahead and go to the next slide. In CTA's lease, or not, in E1's lease, I mean, at paragraph 2.5, they're given a facility access point, and this is from their response. The lease identifies a facility access point as that white box there. CTA's property is adjacent and touches that white box. If you were to ignore that facility access point, you're completely rewriting 332.218, which says the definition of facility includes all structures, other appurtenances, and improvements within the property boundaries used for receiving the storage of organic materials. So it's clear in this case that the CTA's property, in two instances here, one, it touches the facility boundary, or the access point. 2, it's diagonal. CTA has another piece of property that's diagonal to the facility boundary. And for you to accept E1's arguments, you'd have to say that road, the access point, means nothing, and that they can just give notice to their own property owner. And again, in the wastewater context and the underground storage tank context, it's never been done that way. And if you do this here, you know, it's going to change the way people draw their facility boundaries, and it will upset the way that things are done at TCQ. So let's go ahead and go to the first slide for item number 4. Megan, and so that was the first petition for revocation. This petition for revocation is even more clear and more obvious. CTA's property, again, the solid waste facility is identified by the star. They, of course, don't consider the entire property, but they do consider to be part of the facility. So down south, they cut that off. But on the north side, it goes all the way to the road. CTA's property is directly north of that. It's adjacent. It's directly across the street. In the other application, they notified the person directly across the street. In this application, they didn't notice the person directly across the street. And they even provided an affidavit with evidence that's evidence saying that it's their understanding that TCQ's considers property that are separated only by a public right-of-way to be adjacent. And so that's presented to you in the form of evidence in an affidavit. Supreme Court. Did you say time?
I did.
Okay, so all I need to do then is say we ask that you revoke the petitions, and the alternative send it to SOA for hearing. And thank you for your time.
Thank you, Mr. Tuckfield. Appreciate that. Colleagues, any questions for Mr. Tuckfield?
No, thank you.
Commissioner Janeka?
None for me, thank you.
Okay. Well, we don't see petitions for revocation every day, and this is an interesting set of facts on these 2 items, to be sure. We heard 4 separate presentations. I think I heard at least 3 different analyses of these matters, and mine is a little different from what I've heard. So let me add another one to the mix, and then I'll invite your thoughts. And I'm certainly sensitive to Mr. Tuckfield's point about how property boundaries are drawn and the opportunity for gaming the system, that there is some risk of that. I understand what he's saying. I think my view of these matters, the way that I would analyze it, doesn't allow that risk. But let me just have at it, and let's see what you two think. CTA, of course, challenges these authorizations for lack of notice. CTA believes that it's entitled to notice under Section 332.22b as an affected landowner or an adjacent landowner. And CTA points to an error in the rule language, and it suggests that we should read the word affected into the first sentence of the rule. And I actually disagree with Mr. Reed that the rule is clear. I think the rule is not clear. I agree with Mr. Tuckfield that there is an error in the language, but I think that the error is a superfluous "and" in the first sentence that should be stricken. And my view is that the rule uses the words adjacent and affected interchangeably, such that when it says affected in the second sentence, it means adjacent. And if that weren't the case, if we're to follow CTA's logic, I think you would also have to read additional language into the second sentence. And specifically, I think you would have to read adjacent landowners along with affected landowners into the second sentence. So I don't accept that reading of the rule. In my reading, if you are adjacent, you are affected and should be listed to receive notice. And if you're not adjacent, notice is not required. And just as an aside, as to the clarity issue, I would hope that the executive director would initiate rulemaking to clean up this rule and clarify it. But that's for another day. Continuing my analysis, the next question is whether or not CTA is an adjacent landowner. And in my mind, what we're talking about is adjacency to the bounds of the permitted facility. So in this case, we're talking about the leased tract, not the larger tract owned by TMG. Let me also note that I think there's some interplay on this issue with what is meant by adjacency. And so let me get to that point. Because CTA does not actually share a property line with the leased tract, the bounds of the permitted facility, it does force the issue or raises the issue of what is meant by adjacency. Now, I heard the executive director contend that adjacency means only bordering lands. And in the briefing, there was a reference to the agency's compost forms that support this position. But as it's commonly understood, and as Black's Law Dictionary defines it, adjacency doesn't necessarily, but it could include property that is nearby but not touching. So, colleagues, here, I don't think the agency's compost forms are dispositive. It very well could be that adjacency, as we use it here, requires a common property line, but I'm not sure that issue is sufficiently teed up for us to, or at least for me to reach a conclusion about it. I'm eager to hear your conclusions. So let me leave it there for a moment. It's an open question in my mind whether or not CTA's property is adjacent. But setting that aside, let's talk about the consequences. Even for the sake of argument, if we were to consider CTA's property to be adjacent such that notice were required, I disagree that notice is jurisdictional. Under the City of DeSoto versus White, other cases, TCQ versus Denbury Offshore, there's a presumption that notice is not jurisdictional. And I don't see anything in the relevant authorities or the legislative or regulatory history to overcome that presumption. And without that jurisdictional defect, I don't see the present harm to CTA that would be necessary to support the petitions for revocation. Future petitions might be supportable on different facts. CTA might have a private cause of action here, such as for nuisance conditions. TCQ can certainly enforce any non-compliance, but for the reasons I've just laid out, I think my vote would be to deny the petitions that are before us. So with that, Commissioner Lindley, let me ask you what your analysis is.
Well, I have a comment and a question. I want to take a 5-minute break, if that's okay. First and foremost, I need to think on something for 1 minute. But I think where I'm headed in my head, I just want to kind of clear it out and smooth it out, is an agreement and supporting denying the petitions. But I would be happy to listen to my other commissioner first before a small break. That might actually be more beneficial. I don't know. But I'll leave that up to y'all. But maybe just like a 3 or 4 minute break for me at some point, either after he goes or right now would be helpful for me.
Commissioner Ginecka, you want to take a break now, or do you want to?
Well, I'll weigh in. I'll chime in, and I'm always happy to take a moment and reflect on what we've heard, process, make sure we're being deliberative. I appreciate your analysis, Chairman. I think I'm in agreement largely. In terms of the open question you raised, focusing on whether they're adjacent in this instance, I think that I find that there are very different working definitions of adjacency in terms of what notice is required. I think the important factor in my mind is replaying the timeline. Were they given notice? How and where could they have meaningfully engaged with our process at that point in time to provide us information that would have led to a different outcome than where we're at today? That's where I think I'm finding the most practical context to arrive where I think the two of y'all are probably near. But that's largely, I think, issues worth fleshing out and trying to clarify and seek consistency across all of our disparate programmatic areas as an agency, perhaps in another future rulemaking or similar effort. So as the facts are laid out for this particular type to get at these two authorizations, I think I'm inclined to agree that perhaps the appropriate place for these concerns to be addressed is in the enforcement context. But I'll wrap it up, stop there, and perhaps we can have more discussion soon.
Thank you. How about we do this, Commissioner Lindley? Why don't we take a 5-minute recess, give you a chance to, double check and organize your thoughts, and then we'll take those up when we return.
Sounds good. Thanks.
Great. Okay. So the time is 10:43. We'll reconvene at 10:48, and with that, we stand in recess. colleagues, the time is 10:48. We're back in session following a short recess, still discussing items 3 and 4. And Commissioner Janeka, I see you. I think we'll give Commissioner Lindley a moment to rejoin us.
Hi, I'm here, but can I have about 3 or 4 more minutes?
Yes, why don't we 10:52?
Say that again, sorry.
4 minutes would be 10:52. You want to rejoin then?
Sounds good.
Perfect.
Thanks.
Okay. We're in recess again until 10:52.
Thanks.
Colleagues, time's 10:52, and we're back from a short recess. And Commissioner Lindley, Commissioner Janeka, I see the both of you, so we have a quorum and then some. Commissioner Lindley, you want to share your thoughts?
Sure. I don't have a whole lot of thoughts to share. Let me just say I am in agreement, and I'm comfortable today kind of supporting what both of y'all have said, which would be to deny the petitions. I think where I got confused, and I just had to do a little double checking on my end was, we're discussing the term, well, adjacent. Most of the time I I think, of permits. And I think a lot of the cases that might have been cited were regarding permits, and that's not what's in front of us today. And so I just needed to kind of hammer that out in my head a little more. And so I don't really have a whole lot to add other than that comment. And if y'all have more to say, that's great. If not, I can make a motion.
I would like to observe a couple, or share a couple observations I had, and one was just to agree more specifically with another comment that Chairman Neerman raised earlier, talking about the error in the typographical error in our rule that has been referenced by each of the speakers before us today, and I agree with Chairman Neerman's analysis of the rules that the error is in including the word and I do recognize in our rules and in our agency's program area for this activity that there are distinct levels of authorization, the notification versus registration versus where it may rise to the level of a specific individual permit. And I think I shared the exact same concerns that you seem to have worked through, where adjacency is very important in making sure we're consistent and we're fair across the board on all of our activities. And I think the agency may have slightly different working definitions of how adjacency is interpreted and required for purposes of notice. But I think I remain where I was before. I would like to point out that the last part of the rule, that same language where it says, or other affected landowners that the ED requires, I think that's really the area where this concern might have been fleshed out and addressed earlier in this process. And I'm eager to hear from ED staff after this issue today, where their thoughts are and how much back and forth they have with other applicants for other registrations of this type elsewhere in the state, to better understand where does our interpretation of adjacency requirements in this instance, where does that potentially cause breakdowns from the public side, because there's a different expectation of what the word adjacency means in that regulatory requirement, that context. But it's a tough discussion to talk about how to change things always. So in terms of following our process as it's laid out per the various rules and forms, I'm comfortable with revocation, and we'll stop there.
Thank you, Commissioner Janeka. The only observation that I'll share is I think there's some connection between your comments about recourse. What's the recourse on this type of authorization? To my my view on the potential notice defect being not being jurisdictional. But at any rate, it sounds like we're all in agreement. However we get there, that it's appropriate to deny the petitions, and I think I'm ready to entertain any additional comments or a motion.
I would move that we deny the petitions for revocation filed by Central Texas Airport LLC concerning municipal solid waste notification numbers 47068 and 47070 issued to employee-owned nursery enterprises limited doing business as Organics by Gosh.
I second that motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
That takes us to our enforcement docket, items 5 through 21. The Executive Director's staff is here to present these matters.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today is Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 21. The total assessed administrative penalties are $304,815, with $62,173 deferred, $21,064 applied towards supplemental environmental projects, and $221,578 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No questions, thank you.
Commissioner Janeka?
None, thanks.
Ms. Smith, has anyone signed in on the enforcement docket?
We don't have anyone signed in today.
Thank you. Mr. McWhirter, what do you think?
OPIC reviewed these items and we support approval of the orders.
Thank you. I've reviewed the items and agree. I think we should approve them. And Commissioner Lindley, I'll invite any comments or a motion.
I'm in agreement.
Commissioner
Likewise.
Janeka?
Thanks. I'm there as well, and I would move that we adopt items 5 through 21 as recommended today by the Executive Director.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 22 is the consideration of adoption of the repeal of sections 325.1 through 325.3 and the simultaneous proposal of new sections 325.1 through 325.4 of 30 Texas Administrative Code Chapter 325 regarding hazardous substances inventory. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Melinda Johnston of the Critical Infrastructure Division. On the phone with me today are Hoyt Henry of the Critical Infrastructure Division and Amy Robinson of the Environmental Law Division. The rulemaking adoption will repeal and replace Title 30, Texas Administrative Code Chapter 325, to remove obsolete references, provide consistency with federal rules, provide clarity to definitions, and add requirements stemming from the new online reporting system. In addition, the rulemaking adoption will include changes to reduce the number of consolidated filings of multiple Tier 2 reports. The rule revisions for the Tier 2 Chemical Reporting Program were published in the June 5th, 2020 issue of the Texas Register. The public comment period ended on July 6th, 2020. There were no comments submitted during the public comment period. Staff respectfully request permission to adopt this proposed rule. Thank you for your consideration. We are available to answer any questions you may have regarding this item.
Thank you, Ms. Johnston. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None for me, thanks.
Ms. Smith, has anyone signed in on this item?
No one is signed in.
Let's hear from the Office of Public Interest Counsel.
OPIC recommends adoption of the changes to the Commission's Chapter 325 rules as presented by the Executive Director.
Thank you. I agree. The rulemaking here is designed to generate revenue sufficient to support the program. There were no comments. It seems to be straightforward and not controversial. I think we should go ahead with adoption. And let me ask you your thoughts, Commissioner Lindley.
I'm in agreement.
Commissioner Janeka?
I am also in agreement. I'm slightly troubled, and I'm looking back at the caption right now to see how this rulemaking is described. I'm always a fan for full transparency. I think that we were fully transparent and worked with stakeholders very thoughtfully on this rulemaking, and it affects one set of specific stakeholders very specifically. It's a tax increase. It's a fee increase, some form of levy where we're asking for some provision of fee or payment for the permits for that activity. I think this change is very deliberately trying to correct the fact that in fully and adequately running this program as required under the law, the current agency level of effort doesn't meet with the current level of fees generated by the required reports. So we are making a change to the number of reports that can be consolidated when they're sent in, and so the net result is there's going to be more fee revenue coming in. I don't want to be seen as trying to hide that ball, and I don't think we are. It's not tremendously clear in the caption, but I am very comfortable moving forward, and I think that the necessary fees and necessary staff and programmatic resources allocated to this effort are of paramount importance to the state. And I think that this activity being performed well and appropriately fully funded is in the interest of the public and the fee payers. So saying all that, I'm in agreement, and I'm happy to move forward as well.
Yeah, thank you. I agree with those comments, and in order to run the program, the money has to come from somewhere, and so I think that's why this it may be why this rule didn't receive any comments and does not seem to be controversial, but appreciate the observations. I'll entertain any additional comments or a motion.
I would move that we adopt the repeal of sections 325.1 through 325.3 and simultaneous proposal of new sections 325.1 through 325.4 of 30 Texas Administrative Code, Chapter 325, Hazardous Substances Inventory, as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 23 is our public comment session. Currently, we don't have anyone signed in to speak, but we'll pause for a moment to allow the line to be unmuted if there's anyone there to speak. Hearing no one, that takes us to the end of items posted for open session. Items 24 through 27 are for closed session, and the commission will not meet in closed session this morning.
Thank you, Ms. Smith. With that, the time is 11:05 a.m. and we are adjourned.